Welcome to this explainer. Look, today we are unpacking a massive, systemic shift in digital governance. We're talking about a transformation that literally alters how technology, privacy, and innovation all collide in one of the world's largest digital economies. If you want to understand the future of your data protection, well, you're in exactly the right place.
Okay, let's dive into this. Imagine a digital landscape where every single online footprint you leave is tracked, and you have absolutely zero control over who sells it. That's the real-world problem we're tackling today. Millions of citizens are rapidly coming online, using digital payments, accessing government services, but the rules governing all that data, they were written before smartphones even existed. So how do you harness the incredible power of modern tech while putting a lid on unregulated data harvesting? Well, the answer lies in a total overhaul of the legal framework.
To get a grip on this, here is our game plan. We'll trace the digital governance revolution, break down the exact anatomy of the DPDP Act, and look at the new balance between user rights and corporate rules. Then we'll check out the enforcement ecosystem, weigh the critical challenges, and wrap it all up with a master recap.
So let's kick things off with the digital governance revolution and how we're finally moving beyond the old IT Act.
We are looking at a complete departure from the past. Back in the year 2000, India enacted the IT Act. Now think about the tech landscape back then. It was a completely different world, right? Fast forward to 2023, and the government realized a massive upgrade was absolutely crucial. Enter the overarching Digital India Bill. And it's important to understand this isn't just one single law, it's a massive umbrella. It houses the DPDP Act, which we're zooming in on today, but it also covers the Indian Telecom Bill, non-personal data governance, and new accountability rules for social media platforms. It's really a forward-looking, principles-based approach, meant to keep the internet open and safe without choking innovation.
Which brings us to the actual anatomy of the DPDP Act itself: the who, the what, and the where.
Let's zoom right into the crown jewel of this framework, the Digital Personal Data Protection Act of 2023. So the crucial point here is understanding the players on the board. The law basically splits the digital ecosystem into two main camps. First up, we have the data fiduciaries. These are the companies, the apps, the platforms that actually collect and process the data. Then we have the data principals, and that's you and me, the individual users whose data is actually on the line. Knowing who holds the data and who needs protecting is literally the foundation of this entire system.
But where exactly do these rules apply? Well, the territorial jurisdiction is actually huge. Obviously, it covers data processing within India's borders. But here's the kicker. It also extends outside of India if a foreign entity is processing data to offer goods, services, or profile people who live inside India. You can't just pack up, move your servers overseas, and dodge the rules. No way. Although there is a vital caveat here. Specific sector regulations, like strict banking or healthcare rules, will actually supersede this foundational data law where they apply.
Let's shift gears and look at user rights versus corporate rules, because this is where the new balance of power really comes into play.
We're getting into the core mechanics now, and you'll notice some contrasting forces. On one side, users finally have real rights. We're talking clear, simple notices. No more endless pages of confusing legal jargon that nobody actually reads. You can withdraw your consent at any time. But keep in mind, you do bear the cost and consequences of losing access to a service if you pull that consent. On the flip side, companies face heavy obligations. They absolutely must ensure data accuracy. They have to appoint a dedicated data protection officer, and they've got to delete your data the second its original purpose is met. Oh, and they are fully on the hook for your data even if they hand it off to a third-party processor.
The whole architecture here relies heavily on strict, explicit consent. Companies can only process your data for the exact, specific purposes you agreed to. Everything else, off limits. But what about when your data travels across the globe? Well, the center retains the ultimate power to restrict cross-border data transfers. Interestingly, India opted for a blacklisting approach. What this means is that data can generally flow freely around the world, except to specific geographies that the government explicitly blacklists.
And this brilliantly illustrates a really vital legal concept. Privacy is a fundamental right, but it's not an absolute one. There are built-in exceptions. State agencies can actually bypass your consent in extreme scenarios. Think sovereignty, severe national security incidents, or catastrophic natural disasters like earthquakes. It also covers medical emergencies, court orders, and situations where the state exempts its own instrumentalities for foreign relations or public order. It's all about striking that calculated balance between individual privacy and overarching collective security.
Now, all these rules mean nothing without enforcement.
Let's look at the enforcement ecosystem, the real teeth of this new law.
Like I said, a law is only as good as its enforcement, right? The actual muscle behind this act is the Data Protection Board, or the DPB. The center appoints and controls its members, and their powers are seriously sweeping. They can summon individuals, examine them under oath, and physically inspect the books of any company handling personal data. If a platform messes up and breaches the rules more than twice, the DPB can step in and advise the government to block public access to that service entirely. And if a company wants to fight a DPB decision, those appeals go straight to the Telecom Dispute Settlement and Appellate Tribunal.
And when we talk about penalties, we are talking about numbers that will absolutely command boardroom attention. Failing to inform the DPB and users about a data leak, that single breach can trigger a penalty of up to 250 crore rupees. But if a company racks up multiple cumulative breaches, the maximum penalty caps out at a staggering 500 crore rupees. That is a massive financial hit for sure.
Notice the massive paradigm shift happening here. During the old IT Act era, the system relied heavily on the threat of criminal penalties, literal jail time for corporate executives. The new DPDP Act throws that playbook out the window. It completely does away with criminal jail terms and replaces them with crippling financial deterrence. The underlying philosophy? Hitting companies with massive, immediate economic consequences is just way more effective at forcing compliance than dragging them through years of criminal proceedings.
But it's not all perfect. Let's step back for a critical analysis and explore the challenges and stakeholder pushback. Of course, no legislation of this magnitude gets a free pass without intense scrutiny. We need to be objective here and look at the limitations policy experts are pointing out. One of the biggest flashpoints? Protecting minors. The law strictly prohibits behavioral tracking of children and requires verifiable guardian consent for anyone under 18. Obviously, the noble goal is to protect vulnerable kids, but the hidden challenge is the business reality. Keeping age 18 as the hard threshold creates a massive technical and financial overload. Critics argue this will disproportionately crush emerging Indian startups, who frankly just don't have the massive budgets required to build complex parental consent tools at that kind of scale.
And the concerns don't stop at startups. There are major structural criticisms we have to acknowledge. A lot of experts are raising alarms over the DPB's lack of independence, mostly because the center directly appoints its members and retains sweeping powers to block services. On top of that, the business community was pretty shocked by the total absence of deemed consent, a mechanism that usually allows data processing without explicit permission when it's just practically necessary. Then there's the AI bottleneck. The Act excludes protections for personal data already in the public domain, which has created huge anxiety for AI chatbots and search engines that rely on scraping public data. Finally, transparency advocates are really worried this law might dilute the Right to Information Act by shielding government functionaries' data, though the government insists the two laws have been carefully harmonized.
All right, let's pull all of this together with our master recap and key takeaways.
We've covered a ton of ground today, from overarching governance revolutions to the gritty tensions between privacy and startup economics. Let's move to the recap and see how this all builds together. Let's lock in 5 master memory anchors. Number 1. The Digital India Bill is the new umbrella framework, officially retiring the old year 2000 IT Act. Number 2, at its heart, the DPDP Act maps out the strict obligations of data fiduciaries against the new empowered rights of data principals. 3, we've seen a total paradigm shift away from criminal jail time, moving strictly toward massive financial penalties, up to 500 crore rupees. 4, the Data Protection Board brings serious enforcement teeth to the table, even though it faces sharp critiques over its independence. And 5, while user privacy gets a huge upgrade, strict consent rules and public data exclusions are posing severe, real-world challenges for startups and AI innovation.
Which leaves us with this final provocative thought. We're watching a nation attempt to walk a very thin tightrope. As India accelerates its tech innovation while simultaneously throwing a massive security net over its digital borders, will the DPDP Act ultimately succeed in balancing fundamental privacy with true economic progress? Or will the crushing weight of compliance costs stifle the next great startup? The framework is locked in, but the true impact of this digital revolution? That's a story that is only just beginning. Thanks for joining me in this explainer, and remember to keep questioning the systems that shape our digital world.